This part always takes a minute.
Yeah.
Hi, everybody. I am so excited to have you join us today and with one of my favorite experts on the topic of Medicare, Dr. Scott Munsterman. So for those of you who are new to our webinar series, just to let you know, it is being recorded. A link to the recording will be available until the end of time. So make sure that you sit back, absorb all of this great information that Dr. Munsterman is going to share with us today. And just realize that you don't have to take a lot of notes. You can go back and listen to it. It's available immediately after today's live broadcast. If you have questions, submit those through the chat feature throughout the broadcast because, let's be honest, it's Medicare. And we're talking about compliance, and there's always a lot of questions, so get your question in early. If you're not familiar with Dr. Scott Munsterman, well, let me just tell you, he's one amazing guy. He's also the founder and CEO of Best Practices Academy. He's been working through Best Practices Academy, helping to educate the chiropractic profession and risk management and growth strategies for over a decade. He's also a doctor of chiropractic who graduated from Northwestern Health Sciences University, where he also served as vice chair of the board of trustees and on the president's cabinet as chief of care delivery. And did I mention he's also an expert on Macrolaw? Technically, I could go on and on forever on the different things that he is an expert on because pure genius. But anyway, I'm going to be quiet and turn it over to the Dr. Munsterman. Thank you for being here today, Dr. Munsterman.
Oh, thank you, Christy. And I think my mother would be proud at all the generosity that you just did. So, Medicare policy is quite an animal and quite the subject matter to take a look at and to get our arms around. And I'll apologize in advance that what I'm about to share could be overwhelming. But that's why we're getting started. We're going to dip our toe in the water. We're going to skip across it. And the thing that here at ChiroArmor that we want everybody to think about is that we want to help you reimagine compliance because, all too often, and this is what we typically see for practice operations that we encounter, we're in our comfort zone within our practice. From the clinical performance side, we love taking care of patients, the financial management, yep, we got to make things work. And we just kind of operate our businesses from that perspective, taking care of patients, doing the billing, that type of thing. And then there's this thing called regulatory compliance that's kind of out there that either we are a little unsure of or we maybe just out of fear ignore it. And what's important for us to understand is that we need to bring that compliance piece into our operations and make it a culture because that is what completes our operating system as a business. And so as we think about it, from a perspective of how our business operates, compliance to regulatory standards becomes very, very critical. And so to get us started down this road here before we jump right into Medicare policy compliance is asking the question, what is a compliance program? Well, the OIG, Office of Inspector General, has laid out 7 basic components to a compliance program. Now, we're not going to talk about every single one of these today, but we are going to pull out of the mix Medicare policy compliance. But as you take a look at these 7 basic components, you can see that you need to have a compliance officer. You need to implement standards, which would be your policy and procedures based on the laws and the guidelines and the rules that we need to comply to. So what are those? Well, we'll get to that in just a second. And then the monitoring and auditing and, of course, training and education and how do we respond to that? Well, some of the standards that our policies need to address within our practice are in regard to HIPAA, the privacy rule, the security rule, OSHA, labor law, Medicare, Medicaid, which we're going to dive into Medicare in just a minute, our coding, our billing, our documentation requirements, all of these policy areas need to be addressed. Our regulatory areas need to be addressed through policy, number one. And then secondly is that in order to have an effective compliance program, how are you monitoring this? How are you auditing this within your practice? Well, with the standards that we just talked briefly about, there are over 45 different procedures that should be monitored within the practice within a 12-month time period. And there's 12 key procedures that should be audited. And so as you think about it, we have a certain responsibility within our practices, within our business operations, to the regulatory standards. And so the big question is, how is your compliance program working today? I mean, you should have a compliance program that is in force today based on your policy and based on what is it that you're doing that keeps you compliant to your policy. Well, what we're going to do is talk a bit about Medicare policy compliance, and we want to talk about the things that because we are treating Medicare patients, we need to be aware of it. Anytime that we accept federal dollars, there are strings attached. And so if we treat a patient who is a federal health beneficiary, all right, there are federal ties to how that patient is taken care of. And of course, all of this is found within the Medicare Benefit Policy Manual, and we have the link there for your convenience. So let's talk about some key compliance issues, because that's what this is all about. And so this is just a list, a little bit of a laundry list, if you will, of the areas that we're going to touch on here today. And again, I apologize for throwing a lot at you, but there is a lot. And if it spikes your awareness in these areas that you're saying, oh, you know what, I need to check into that, then our mission was accomplished today. But we're going to go ahead and jump right in today. So let's first of all just talk about opt-out. That's one of the provisions that are not available for the doctor of chiropractic. And matter of fact, there's been talk with, the new payment system, or maybe the documentation standards, like, gee whiz, I'm just going to opt out of Medicare. Well, you can't opt out of Medicare under the general opt-out rules that other providers are able to use. You are either in or you are 100% out. And so you can't be off the radar. You can't treat Medicare patients for cash. You can't be a maintenance practice and force a patient to sign box 2 of the ABN to be a patient. I mean, these are all some creative ways that maybe some doctors in the past either have went off on their own to do, or maybe they've listened to somebody that said that it's okay to do that. Well, you can't do that. You can't opt out. It's either an all or nothing thing, and you cannot creatively code to have only non-covered services. And of course, one of those that we see out there is saying, well, I'm just going to treat everybody as a 97140 visit. I don't need to bill Medicare. I'll just charge the 97140 and the patient can pay cash. Well, there's a couple of issues with this. Number one is that it's important that we code to the highest level of specificity. And so if our documentation states that we manipulated an area, then guess what? The manipulation code is the code to use. And the fact is that if you were audited and your patient was interviewed, the question you need to ask yourself, would the evidence convict you of performing manipulation? Fact of the matter is that is somewhat of a scheme. And so again, we can't opt out. So let's talk a little bit about the Lincoln Law, or the False Claims Act. Well, what's that all about? Well, this is an act that establishes liability when any person or entity improperly receives from or avoids payment to the federal government. Well, you might ask, okay, what's that all about? The term inducement is a big part of that. And of course, what it means to induce is that it's to lead by persuasion or incentives, or your motive is to try to get something in return for that. So for instance, the big thing here that we have to be aware of is providing services at no charge to Medicare or Medicaid patients. Let's take a look at a case. This was a recently decided case from the Department of Justice. This doctor actually was alleged to have violated the False Claims Act by improperly billing Medicare, Medicaid for chiropractic adjustments after providing free electrical stimulation to those patients. And of course, the DOJ believed that free electrical stimulation was to influence them to come and see that doctor. And they alleged that this conduct violated the Anti-kickback Statute and in turn the False Claims Act. Okay. And of course, the inducement by providing free services to Medicare patients, and it included both active treatment, maintenance care, and the complaint. And then also what was brought out was that all maintenance patients were coded as a 98940. And again, not coding to the highest level of specificity. And so the compliance fail point here behind this particular case is understanding that Medicare prohibits any actions that would be considered inducement to a potential or an existing patient. So the inducement part of it is there, but then they also prohibit upcoding or downcoding procedures. And so again, to the point of making sure that we code to the highest level of specificity, that what we have documented is very important to match up with our coding. And what can we learn from this particular case? Well, it's to not offer or provide free services to Medicare patients, including exams, therapies, and treatment. And that means do not include Medicare, Medicaid patients in any coupons, Groupons, or any other types of advertising system for new patients, and do not downcode or upcode services. Again, very important from a compliance perspective. So let's talk about professional courtesy. Again, we're jumping across the water here. And so professional courtesy is all about offering free care to a particular group of people. And it could, there's a general understanding here, first and foremost, is that there is a prohibition on paying, offering, soliciting, or receiving remuneration for referrals, all right? And so professional courtesies have to be very careful when we move down that road of providing care. Now, the Stark Law has weighed in on this, on the provision of free or discounted care, all right? And the Stark Law essentially says that if you're going to offer a professional courtesy to an entity or a group of people, which we'll talk about in a minute, a couple of guidelines there, it cannot be with regard to any volume or value of referrals or any other business. So it cannot be in lieu of type of a thing. And the second thing that they state is that it needs to be a service that's routinely performed or provided by the entity, and that it is written in policy and in advance and approved in advance by your board. Now, there are other folks that weigh in on this, and the Office of Inspector General has a few things to say about professional courtesy as well, because they oversee cases that may conflict with the anti-kickback law. So what do they have to say? Well, two key things here, all right? They say that it's all dependent upon how the recipients of the professional courtesy are selected, and then how the professional courtesy is extended. And so how they are selected. So let's say, for instance, most doctors have their staff or provide free care to their staff. Perfectly fine. You've got that well identified that anybody that's employed by your clinic will qualify for free care. You're extending a professional courtesy to them. So you've got your group of recipients right there identified, and it has that limitation because they're employed by you. How that is extended, however, is that you can provide that free service then to that group, which is your staff, but you cannot in turn turn around and bill insurance for those services. All right, and so that's the situation that the Stark Law and the anti-kickback law bring those factors to light. And so, what about family members of doctors? Okay, well, that's a really important point. Is that under Medicare, it stipulates that a clinician cannot bill for services or ordered services for immediate relatives. You may say, okay, well, immediate relatives, that's probably my mom and my dad. Well, actually, it extends a little bit further than that. It can be a husband and wife, natural adoptive parent, child, or sibling, steps, in-laws, okay, grandparent, grandchild, spouse of grandparent, grandchild. And then they go on to say that even a step relationship or an in-law relationship, that they continue to exist even if the marriage upon which the relationship base terminates through divorce or through the death of one of the parties. And so the immediate family definition even extends to that point, which you may think, wow. But this is a very important point to note. Now, we have many professional courtesy scenarios that we can provide. Just let us know, and we're happy to send that to you. So let's move along. OIG exclusion list. If I could see you, I'd ask for a show of hands. How many of you know what the OIG exclusion list is? And when I ask that amongst a group of colleagues in seminars that I provide, typically within like a class of 100, I probably have 2 doctors actually raise their hand. And about 3 kind of raise their hand or they want to, but they're not really sure. Well, the OIG exclusion list is a very important list that has identified individuals, or entities that are excluded or debarred from federal programs. And so we've got a case here. There was actually a chiropractic physician in the Midwest, got a letter from Medicare, and he was excluded from Medicare for 3 years, and they had requested all of the funds back in the last 3 years. Well, why is that? Well, it was because he had employed a staff person who was on the OIG exclusion list for a prior offense, which we'll talk about in just a minute. And so this impact to the practice can be huge. If you are not checking your staff against this list periodically, and we'll talk about that in a minute, as well as new hires or any vendors that you have business associate agreements with. This payment prohibition applies to the excluded person, anybody who employs that person or contracts with that person. And so that it's far-reaching when it comes to the relationship with that individuals. Now, there are mandatory exclusions, which we're not going to jump into, but this is on the slides for you to review. And there's also permissive exclusions, which give some leeway as to the penalty. But this link right here, you can utilize, will bring you right into the information about the exclusion. And this particular link will allow you to search for those employees. So you'll want to search all new employees before hiring. You'll want to do existing employees on a quarterly basis. And of course, I always recommend to our clients that if you catch wind of something, or maybe you're suspicious, do it sooner than quarterly. And of course, all business associates before hiring and on a quarterly basis is important to do. And so the point is that you are protecting yourself by making sure that the people that you have in your business or that you do business with are not on this exclusion list. And then this is a great link. I thought I'd leave it available for everybody. There's a frequently asked question list that I found that's on the OIG site. You can click on that and you can learn probably more than you want to know about the OIG exclusion list. So let's talk a little bit about par versus non-par provider. What's the difference and how do you comply? Well, there's somewhat a little bit of fuzziness sometimes as we talk to doctors about this. And the long and short of it is that Medicare does set limiting fees, which I think we're all familiar with for both par and non-par. Typically, the limiting fee for the par provider is slightly higher than the limiting fee for the non-par provider. And in regards to active treatment, okay, Medicare directly reimburses the par provider for the payable covered services that they provide. And then the patient's required to pay for the non-covered services. And of course, for non-par providers, the patient is required to pay that non-par provider for all services performed. And what is probably not known very well amongst our colleagues is that the patient is under maintenance therapy now, as we talk about maintenance therapy, that the patient is responsible for all services provided up to the provider's normal fee. And so the limiting fee does not apply to non-payable covered services. And so just a couple of tidbits along that. So let's talk a little bit about billing services. Okay, all covered services provided to a Medicare patient must be billed to Medicare. No exceptions to that rule. All covered services. And of course, your patient has the option to determine if non-payable or non-covered services may be billed to Medicare by completing the ABN form. And so if you have a covered service that you deem will be non-payable because maybe they're on maintenance therapy or for whatever reason you feel that Medicare wouldn't deem it as medically necessary, or if there is a non-covered service, that's where you would have the patient complete the ABN form, and it's at that point that they would have the option to determine, that it should be billed to Medicare or not. But all covered services provided to a Medicare patient must be billed to Medicare. Informed consent. You think Medicare policy compliance, what does that have to do with informed consent? Well, within the Medicare benefit guideline or manual in Chapter 15, there's a section called contraindications. All right. And it goes on to say, dynamic thrust is a therapeutic force delivered. A relative contraindication is a condition that adds significant risk of injury. And then it goes on to say in the third sentence that the doctor should discuss this risk with the patient and record this in the chart. And then they go on to talk about the relative contraindications. Well, that's our informed consent, folks. And so what's important to keep in mind is that as a documentation standard or guideline, we should say, within the Medicare Benefit Policy Manual, it's important to include and put in the record that you did discuss the risk and that you obtained informed consent from the patient. All right. Very important. It's one of those things that maybe you didn't think about. Security risk analysis. Let's talk a little bit about that, because this requirement, and this is another one of those things that as I ask colleagues when I'm out and about and speaking, what's a security risk analysis? Well, many doctors have heard about it, but they don't really know what it's about. Or they think they maybe, I think I did that, or I think I got that done a while back when I put it in my computer system, but they're not really sure. Well, a security risk analysis is a very detailed analysis to detect if you have any vulnerabilities within your practice, within your system. And essentially, it follows HIPAA guidelines in terms of security risk analysis and HIPAA policy requirements from the privacy rule perspective to the security rule perspective, administrative requirements, technical requirements or safeguards, and physical safeguards. All of those with a number of questions and a number of areas that we need to check to make sure that we are crossing our T's, dotting our I's to eliminate or control any vulnerabilities of losing PHI or somebody coming into our system and stealing PHI from us. And so there's a HIPAA requirement that we need to go through that process at least every 2 years, unless we've had some relevant changes within our practice. Let's say that you bought a new server, or maybe you moved your practice location, or maybe added a bunch of equipment, anything that would cause a change, or maybe you had to change your policy manual or something like that would say that, okay, this was significant enough, we better recheck to make sure that we are not vulnerable again, so to speak. And then secondly, Medicare's quality payment program, and you've heard of the Macrolaw or merit-based incentive payment system. Part of those requirements is that the security risk analysis is actually done on an annual basis. And so security risk analysis, a very important part. And again, it's about conducting accurate, thorough assessment of those potential risks, vulnerabilities, protecting PHI, and it includes addressing like the security of including encryption into the certified electronic health record and the like. And so again, that's a whole nother conversation to have and discussion to have. And so we've covered a number of key Medicare policy guidelines that maybe we haven't even thought about, right? Because the one that really seems to come to mind the most is our documentation. And many doctors that I speak with, that is all they think about is that, well, yeah, I got to make sure I have my notes done right and all of that. Well, that is exactly true. As a matter of fact, that is on the top of the OIG's work plan for us is documentation. But it's important to not lose sight of all the things that we just talked about, because all of those other things that we talked about are very key to how our compliance program should function and should work. But let's direct our attention now to what we think is like kind of the obvious. And I love this quote. It's by Dr. Taylor out of Texas Chiropractic College. It was in a article that he wrote a couple of years ago, and he talks about the need for chiropractic record improvement, a diligent educational process, making sure you have the right EHR, paying attention to implementation process, training your staff, doctors being trained, having appropriate utilization, be attentive to data entry, and to maximize the features and customizing your software. I mean, when we think about documentation, we think in which we should think about, I need this component, I need this element to make sure I have a good, valid claim. Well, what this kind of brings into the picture is that, yeah, that's important, but we're also operating an electronic health record. And we have some limitations sometimes. We have some nuances sometimes. And so we have to, it's a bigger job to make sure we get documentation done right, because we have to think about all the other moving parts that surround it. How we're developing our treatment plan based on protocols, our evidence-informed practices. How do we get this in the EHR? How do we get it so that we can customize it to make sure it's encounter specific for the patient? Maybe we need to train staff to help us, on the helping us get it into the record, the scribe part of it. All of these factors need to be taken into consideration. And then in addition to the guideline, that are set forth within the Medicare Benefit Policy Manual. And so we're just going to cover a few of these key issues. Many of these things I've learned from Dr. Conway. I give kudos to him and Dr. Jacklich. They have led the way. They have seriously led the way on helping our profession get this right. And so the patient history, very key, very critical. Review a system, family, past social medical history, treatment plan, specific patient goals, and of course, demonstrating changes since the last visit. Now, all of this needs to be within the understanding that when we take that patient on, we are going through an initial visit, which we'll talk about those requirements in just a minute, but we are defining an episode of care, which is a beginning and an end, and that it also tells us, or we will be telling the story as to how we're going to manage that patient in between those two bookends, if you will. And so it begins with the initial visit. We will, go through what we need to go through here in just a minute, talk about that. But then establishing that treatment plan for this particular episode of care. But we need to be thinking about, we're defining an episode of care for this patient as they come into our practice. And we need to make a decision, is this active treatment or is this maintenance therapy? And so as just as kind of an illustration to help us wrap our heads around this, we can think about the care of the patient. Typically, they come in, they're acute. And then we've got an early phase of care that helps them get through that acute phase and into the subacute phase, and then eventually into the chronic phase of care. And that our active treatment is going to carry them through to the point where we've achieved those goals, or we've reached that state, either the pre-incident status of the patient, of where they were before the injury, or their maximum therapeutic benefit. And then at some point, at the end of that discharge or end of that care, then they are released to maybe maintenance therapy if that's appropriate. And certainly there is medically necessary care, which we just described, getting the patient through the acute, subacute, chronic stage of the condition. But then we also have clinically appropriate care that may extend beyond that point in terms of supportive or maintenance therapy. And so getting our grasp on that is really important. And of course, Medicare has an opinion, and their opinion is that maintenance therapy is not considered to be medically reasonable or necessary and is not payable. And that point, if you will, or that threshold is crossed when no further clinical improvement can be reasonably expected. And it's at that point that treatment is considered maintenance therapy. And so if they review a record and if they see that, oh, it looks like that patient's not getting any better, their symptoms haven't changed, their function hasn't improved, I think they're done. I guess they're done. That the treatment at that point, when no further clinical improvement is reasonably expected, then you're into maintenance therapy. And so we have a number of documentation requirements fresh out of the Medicare Benefit Policy Manual. The history, we're identifying the chief complaint. Our history of present illness is describing what that complaint's all about. And of course, family, past medical, social history become an important part. And then identifying what are the functional limitations that individual has. What is the pain restricting and limiting in that particular region of complaint. And then, of course, our examination of the Medicare patient, PART, we need to follow. And by following that and or X-ray, we're able to determine if a subluxation exists in that region of complaint. And then, of course, getting into the clinical decision-making with the treatment plan and how we set that apart. Now, very critical, again, we're skipping across the water here, hitting high points, right? Would be determining the causation. And so mechanism of trauma is very key for our documentation of what brought this on. What is the causal factor of what brought this on? Well, you and I know that as we take care of Medicare patients, maybe even most of the time, they're not really sure what brought it on. And so we put in our notes insidious onset, or we put in our notes unknown origin of pain, or unknown origin of what brought the condition on. Well, the problem with that is that it doesn't describe what didn't cause the problem. And to put insidious onset or mechanism unknown or cause unknown isn't enough to fulfill this mechanism of trauma or determining causation. And so what we need to do and make sure we do is when there is not a clear definition of what caused the condition, then we need to rule out what didn't cause it and put that into the notes. And so, for instance, and you and I do this, is that Sally comes in and it started a week ago, but she doesn't know what brought it on. Well, what do? Well, we're pretty much start to question Sally, don't we? I mean, we start asking her, well, did you take any trips, or did you slip, or did you fall, or did any of this happen? And so we may run through 3 or 4 things, and Sally's like, no, none of that happened. And you're like, okay, well, let's move on. And it's important to document that we did take that history of ruling out what didn't cause it and have that in the record, because it substantiates that, okay, the mechanism isn't clear, but we're going to move forward now into the history and the exam. And so that's very key. And then identifying, is there a time lapse of when maybe a mechanism did happen, but the patient didn't come in until a month later? Asking the patient, okay, why is that? And documenting that time lapse so that that's understood in the patient record. And so again, mechanism of trauma, identifying that, and do the symptoms correspond, and are they consistent with the mechanism of trauma? Are they consistent with the region where the subluxation is in? Okay, and is your functional limitation also consistent with all of the above? So you have this triangulation of events, if you will. You've identified the mechanism, the causal factors, and or region of complaint. You've identified if there's a subluxation in that region, and you've tied a functional limitation to that region. Now, that's very important, because as we move forward into treatment planning and into documentation, that we have to make sure that those goals are based on those functional limitations, in addition to pain and or maybe some range of motion objective findings. And of course, as I mentioned earlier, identifying the subluxation, PART, and of course, asymmetry and range of motion abnormality need to be mentioned in our treatment plan. Another very key linchpin to Medicare documentation. As a matter of fact, if I'm going to quote Dr. Conway, a good friend of mine, he says probably 99% of our problems are that we don't have a treatment plan, or we haven't spelled it out very well. And so what does that mean? Well, we need to make sure that we have patient-specific goals. It doesn't mean that gee, they should get 50% better on their oswestry, outcome assessment tool. That's not specific enough. No, what we want to know is how long can Sally sit for? How long can she stand? I mean, how long can she walk before she has pain? What could she do before the injury? Well, a great goal would be to start with would be our pre-incident status, right? And so beginning with a goal that maybe where they were before, and that's where we want to get them back to, it can be an important part. Patient-specific goals. And so having a pain goal, you know, they're coming in on the visual analog scale with a pain intensity of 5, but they were a 1 before this whole thing started. Well, a great goal would be to get them to a 1. You know, ADL, specific activity of daily living, like we mentioned, or maybe, you know, a range of motion goal, objective goal, but patient-specific, 2 to 3 goals are great. And so as you think about the number of goals being very specific, that's important, okay? Duration of care. You know, we mentioned earlier about the episode of care and saying, okay, we're treating this patient for this episode of care. Well, to define that episode, we need to know how long that episode is going to last. And we typically will understand that based on our exam findings, maybe based on patient preference, maybe based on any treatment barriers that could be existing that could extend or prolong the care process. And so our duration of care may be 4 weeks, it may be 2 weeks, it could be 3 months. You decide, you're the clinician, but we set that out. And then the last thing is the frequency. How many total visits will this take to get this patient through this episode of care and achieve goals and reach discharge? All right, so that's what a treatment plan is all about, laying that out, patient-specific goals. How long will this take? Duration of care. How many total visits will this take? Very critical, very key part, and putting the time into that initial visit is absolutely essential for us to do. And then, of course, coding properly, making sure that we have subluxation in the first point, and then condition-based codes thereafter. And then, of course, that brings us to our subsequent visit. And what do we need to have included within that? Well, you know, the key thing here that I want to leave with you is that subsequent visits need to demonstrate how that patient is doing for that day. It needs to be relatable to the chief complaint, you know, obviously, right? And if you can identify changes since the last visit, you know, what changed on the subjective findings? Did the pain intensity level move? What changed on the function? You know, can they sit longer? Can they stand longer? Is there improvement from a subjective perspective? From a physical exam perspective, what's changed in your objective findings? You know, I'd say based on my 35 years of experience as a chiropractic clinician, did objective findings change every visit? No. Did they change every few visits? Yeah, I expected them to. And I think we all do. And so updating those objective findings are very important. And it's important to understand that these are primarily therapeutic visits. And then we're comparing from the last visit, and then we're reviewing, we're commenting on the progress, because again, we're working towards trying to reach those goals. And of course, a very serious issue to CMS and the OIG is not having fresh notes, not having encounter-specific notes. And of course, that's referred to as cloning. And to just copy over what you did last time and call it good is not good. And so very important that even in light of the nice ability that we have, convenient ability that we have within EHR systems to bring forward maybe some redundant information that needs to be in the record but doesn't change. What does need to change are your subjective, are your objective, and your assessment. And if you did something different in your procedure or recommendations, that needs to change as well. So let's be very careful, very cautious about how we move forward with that. We did touch on the ABN, again, another Medicare policy compliance piece. And of course, and this is just a good take home here. Its twofold purpose is to, number one, protect the beneficiary, because then they get to choose what services they want, you know, what they want billed to Medicare or not. And it protects you, the provider, and it allows you to collect payment from the patient if Medicare denies that service is not medically necessary. And again, you know, we talked briefly about this, you know, medical necessity, the definition, reasonable and necessary, and it needs to improve the functioning. You know, as you think back to what we talked about on the documentation side of everything. And we talked about that specific patient activity or specific patient goal, which by far the most important goals that you can have relate to functional limitations of specific things that they do throughout their day. And so that's where it's at, is like, what are we doing to improve that person's life? It's not all about the pain anymore. I think the opioid crisis pretty much put that to bed. What it's about is improving function. And that's where everybody is at. And so what we did as well, for your convenience, we included links to the national coverage determination and local coverage determination. So you can go right on these links and you can click on and you can learn more about both of those, and specifically for your particular region. And then the last thing that I want to talk about, Christy actually brought it up briefly, is the Macrolaw or Medicare's Quality Payment Program. And you may wonder where we're at with this new payment system. And of course, what has dictated clinician involvement or participation, not your eligibility, because all chiropractic clinicians are eligible. All right, that's number one. I want to make sure everybody understands that. But your participation has not been mandated, or may not have been mandated yet. Let me rephrase that. If you have not reached or exceeded the low volume threshold. Now, that low volume threshold is a threshold that was put in place right away, and it has changed year by year, and it will continue to change year by year to include more and more eligible clinicians. And so this needs to get on your radar because we could be looking at a year or two or three, and we will be in full bore. Whereas other clinicians since 2017 that have been included right away have had this ramp up period of time. Do you see where I'm going with this thing? And so probably unfortunately for us, we thought we've dodged the bullet, thinking that, it doesn't apply to me, it never will. Well, that may not be so. As a matter of fact, there's a high likelihood that that low volume threshold will continue to capture more and more eligible clinicians. And so begin to put this on your radar. Currently, the way that it's set is that you have to have 90,000 in allowed charges and 200 unique Medicare patients in order for you to be mandated in. Well, they've since then added 200 services, which could be all on one Medicare patient, theoretically, all right, and a voluntary opt-in. And so I believe, and this is just my opinion, all right, that they are beginning to open the door to lower that threshold down more, to include more clinicians that are smaller and may have lower volume of patients because they've gotten the program through, they've gotten it up and running, they've got quite a few bugs worked out of it, and now I believe that they will begin to open this up over time. And so get it on your radar. Again, the quality payment program categories, quality measures, there's also a cost category, which the Doctor of Chiropractic is not a part of. All of the measures points go into the quality category, so it makes quality very important. And then, of course, promoting interoperability, which used to be the old meaningful use, and then improvement activities, which is another new category. And not to dive into this deep at all, but the key is that we need to understand these. And one way that you can understand this and get a good indication of where we're at, we just recently released a white paper. It's kind of the state of the state on the Macrolaw, on the quality payment program, and it's free of charge. You can go to this link, you can download it. If you are mandated, and there are some chiropractic clinicians that are mandated currently that they've reached that threshold. We also have a manual that will help you through the process. And so, my big question here as we close, Christy, I want to thank you again for the time and in letting me talk. This is always good therapy for me as a compliance consultant to kind of talk about these things. But what I want to leave you doctors with is really this key question: how does your compliance program work? I mean, how is it working today? I mean, and I don't mean like the results you're getting. I mean, can you explain if somebody walked in your door and asked, show me your compliance program and show me how it works inside your practice? Does it comply to all the regulations? Can you show me in the policy manual that you've got the privacy rule under HIPAA, all the three safeguards under the security law, that you've got everything covered under your OSHA? If you've got X-ray, do you have an X-ray policy? Do you have a general safety policy? Do you have a hazard communication policy? Do you have an emergency policy? Do you have guidelines when it comes to billing and coding and documentation? Can you show, does your policy comply to being able to show guidance inside your clinic for you and your staff as it relates to all the regulations? Secondly, are you monitoring and auditing those different things that would keep you compliant? Are you monitoring and auditing those inside your practice? What are you doing each month that will help you know that you're staying on track, that you are complying? Do you keep up with the required training? First of all, and I think the key, there's annual training. It seems like us doctors are, I got to get that annual training in, fraud, waste, and abuse, and HIPAA and OSHA. 3 federally required annual training, right? And now we have insurance companies and payers that are saying we need even more than that. Models of care training and cultural training and some of these other patient engagement training, which is all good. But we have a tendency to say, what's required of me for me to just get by? And that's important, okay? Don't get me wrong, but we're missing the greater question, and we should also be asking, what do I need and what do my staff need to get me up to speed to have the knowledge base I need to have so that I have a good, effective compliance program working, which means, as we relate back to the very first slide we talked about, my business operations. How important is compliance to any business? Keeping up with the regulations. It's pretty important. And that's a key component that we need to bring in and embrace within our business model. And then the last question is, how am I keeping up with all the changes that are occurring? And what I hope here, and again, thanks, Christy, for this, but I hope that this presentation has kind of either caused you to say, oh my gosh, I have everything covered. Good. And it may cause you relief. And I hope it does. I hope this finds you in a place that, oh my gosh, we got that covered. We got that covered. Maybe we need a little work there. I'm going to check into that one. And that'd be great. If you're in the practice though, or running the practice, that you look at this and you think, oh my word, I didn't know half those things, or I wasn't aware of some of those things. It's really time for you to kind of take that step and learn more and learn as much as you can. So with that, Christy, I'm not sure how close I came to the end of the time here, but I'll just pause and let you take over.
Thank you. I have to say that I've heard this presentation many times, and I always learn something new because it is like drinking from a fire hose. So take a deep breath, everybody. And we do have a few questions. We have a lot of great questions, actually. So the first one says, can you discuss inducement versus timed therapy CPT codes? When only one service is provided in a day, providers should not bill for services performed for less than 8 minutes.
Correct. And so what's important is that, and again, this was the example that we gave you was under Medicare. And that's a little bit of a quandary when it comes under Medicare. Because in that particular case that we showed, and this was a case that, I've listened to Dr. Conway talk about. I mean, it's one of his slides that he allowed me to use, that doctor was under that assumption, and we can't be under that assumption. And so in that particular case with Medicare, what we learned from that is that it needs to be billed.
Our next question, how do you code as a full spine practitioner when they only have one area of complaint?
So when they have one area of complaint and you have a subluxation in that region of complaint, then your manipulation would be that 1 to 2 region manipulation. Even though you may be adjusting full spine, what you are adjusting then are what you could refer to as compensatory, and that they are not directly related or medically necessary areas for treatment. And that's how Medicare would view that. And so don't kill the messenger. If you have, and this is where the mechanism of trauma is important, the PART, again, defining subluxation or x-ray in that particular region, and having a functional limitation that's tied to that particular region. That's what Medicare considers to be the factors revolved around medical necessity.
Okay. Our next question says, are we allowed to discount services for Medicare patients?
No. And if you've got, and this is where ChiroHealthUSA step in here, Christy, would be a great great advertisement there. Of course, under a discount medical plan, you can design fee schedules, but at the end of the day, you cannot give care away for Medicare patients. Now, if you have your financial policy in place and you've got a hardship, and if that patient, excuse me, applies for that hardship through an application process, and then within your hardship, you give a certain discount, then that is fine to do. But unless or until that happens, the answer would be no.
Right. And I just want to add clarification on hardship. They have to meet the criteria within your hardship policy, whatever that is. A lot of consultants recommend using state or federal poverty guidelines before issuing that discount. So just make sure that they're meeting that criteria. But otherwise, you could offer discounts on non-covered services to your Medicare patients using a program like ChiroHealthUSA.
There you go. Thank you.
Can you offer a complimentary or free consultation to a Medicare patient?
If the service that you're providing, you typically charge everybody else for, the answer is no. If it's something that you're charging everybody else for, but you say, I'm not going to charge this, Medicare patient, the answer is no, you can't do that.
All right, let's see.
If you charge for a procedure, you need to charge for that procedure across the board.
I don't see any other questions coming through, but if you are like me and think of your questions 5, 10, 15 minutes after the webinar has wrapped up, or even the next day, you can reach out to Dr. Munsterman at info@chiroarmor.com. They are amazing and will very quickly get back to you and answer those questions for you. So just a reminder, next week, we're going to be talking about documentation with Dr. Dean DePice, and we're super excited to have him back on the webinar series. It's been a while since he's been able to visit with us. And then the following week, we're going to have Dr. Evan Gwilliam talking about confusing codes for chiropractors, 97110 versus 97112 versus 97530. So we're super excited about that and look forward to having you join us. And make sure you go to our website at chirohealthusa.com/webinars and register for any of the upcoming webinars that you find interesting. Just know that, again, all of them will be recorded, and access to those recordings will be made available to everyone who registers immediately after the webinar. And it looks like we are updated into October for upcoming webinars. So we're super excited. Should have everything posted through the end of the year and the next couple of weeks. And it's hard to believe that we are saying the end of this year. That kind of hurt a little bit. But anyway, so thank you so much, Dr. Munsterman, and thank you to all of you for joining us today. And we will see you next week, same time, same place. Have a great day.
Yep, bye now.